Okay, Daniel, as I was just telling the class, we did 2 charts already. We did levels of protection by type of medium, and then we did levels of protection by type of speech. And now we'll do levels of protection by type of, let's do forum first. By type of forum. So simply put, this just means that you get varying levels of protection depending upon where you are when you're speaking. And so this is, the court has developed what legal scholars call forum analysis. So often in a speech case, after we've got past our threshold questions, such as is it speech or is it action, etc., is it content neutral, is it viewpoint discrimination, the court will often have to determine whether the place you were doing the speaking affects how much protection you get. So, what places do you think, if you're speaking, let's say you want to go out and you want to protest bombing Syria, what are the types of places that you think would get the most First Amendment protection? What do you think? Just use your imagination.
Public space.
Some sort of public space, like what?
Maybe like a park.
A park, right? So a public place like a public park. What else? Use your imagination. A street, because that's a public byway, right? A sidewalk, right? A street or a sidewalk. A park. Out in front of the courthouse, right? If there's like a public square, there's often a public square in front of the courthouse, right? And so these are by custom and tradition, right? It's like you don't have to read this or learn this, just your intuition tells you, just by custom and tradition, because we see people doing that kind of thing. We see people, when you can picture in your head people with picket signs going up and down a sidewalk. Or they're out in front of the Supreme Court building on the square in front of the Supreme Court. And so these are very traditional places, and the idea comes to us from English common law, right? Since time out of mind, all the English-speaking peoples of Christendom have agreed, right, that these public places are places for us to debate and talk politics and that sort of thing. And so we can just say, traditional public forum. What we're looking for is public forums, because those are the places where our speech rights are going to be protected. They have to be public forums. This is the floor of First Amendment protection. Floor of protection. Anything below this line doesn't get protected. Like, you are not protected by the First Amendment at all if you are speaking in any place that falls below this line. So what does your gut tell you then? Where would be a place where you don't have any First Amendment right to speak?
Any type of like
Private property. So we're looking for public forums, or public fora, if you want to be Latin about it. Public fora where you do have First Amendment protection, and private property where you don't. Which amendment to the Constitution tells you that this would be so? You would justify your answer by mentioning which amendment of the Bill of Rights. It encapsulates the idea that a man's home is his castle.
I don't know exactly, but is it when the government, like soldiers couldn't come into the home and
Quartering of troops, the Third Amendment?
not do about them?
Because that's really about government agents, right, intruding on you. Which amendment protects your privacy? Which amendment, when we were looking at the NSA spying story just a minute ago, which amendment, what right is the government violating when it does that?
Right to privacy.
Mm, could say, you could do right to privacy, 14th Amendment violation, right? You go to the word liberty, and if you, the word liberty is like a hot link, and if you click on it, a pop-up box comes up, and it shows all of the rights that the Supreme Court has inserted into the word liberty, and privacy is one. So good, you could do 14th Amendment privacy, due process privacy. What else? Did the government, let me ask you this, did the government ask you to take the contents of your email and text messages?
So is it like almost like
Search and seizure, illegal search and seizure, unwarranted search and seizure, which is Fourth Amendment. So we could say, you guys already know enough about constitutional law to say that what the government is doing is violating two very important rights. 14th Amendment, due process privacy, and 4th Amendment, guarantee against warrantless search and seizure. Awesome, good.
So now, because of like with the advance in technology, search and seizure, like if you take that to a court, would they include email and stuff like that?
That's what then courts have to decide, especially when we get new technologies. We have to figure out, okay, well, how do the old rules apply to this new technology? And courts have been struggling for years with how to deal with email.
And how can the government just like take your property like you were talking about?
They are not supposed to just, right? They're not supposed to just do that. They're supposed to get a warrant. What do they need to get a warrant?
A judge's approval.
A judge's approval. And what do they need to prove to the judge to get his approval? Probable cause. Right? That's why we have a system in place. It's a check on government abuse of power. And they have been going around that and taking your emails and your text messages and your Twitter, everything. Well, that's public. What's something else that y'all do? Text messages and all of this stuff. And they've been taking it without getting the judge's approval, right? This was in the old days, since we have a little flexible for time here. In the old days, what Mr. Blackshaw just described as just taking the stuff would be a general warrant, right, where the government comes and they don't even know, they don't have probable cause, they don't even know what they're looking for. It's just a fishing expedition. They're just going to get everything. And then they might find out that, oh, lo and behold, you have some crack in your dorm room, or you've got some illegal guns or something like that. But they're not supposed to be able just to do a fishing expedition like that. Like if they suspect that you're selling drugs, they have to have some proof that they have a reason to believe that, right? Maybe somebody told them or something like that. So one of the things in the Declaration of Independence, one of the items that we were rejecting about England was this idea that they could just come and search your papers and search your home, which is why it's in the Declaration of Independence and then it's enshrined in the Fourth Amendment.
So maybe I missed it, but so why are they still why do they keep doing it? Are people like
They keep doing it because they are flouting the law.
shouldn't somebody do something about that?
Yeah, shouldn't somebody do something about that? Shouldn't the Obama administration do that? Whose responsibility is the CIA and the FBI, those agencies? Is it judicial branch, legislative branch, or executive branch?
Executive.
Executive branch. So why isn't Obama doing something about it?
Probably get on.
That's my question, right? That's my question, Ms. Klink-Mueller. You know, why isn't Eric Holder, who is the Attorney General, why isn't he prosecuting people? Or at the very least, why hasn't anybody even been fired? Don't you think at the very least somebody should have been fired for doing this? Well, see, then who is the government making out to be the scapegoat in this case?
Snowden.
Snowden. Snowden is the one who revealed all of this to us, and we should thank him for that. That's what a whistleblower does. They uncover government wrongdoing, so the government instead has been trying to attack him and threaten him. Isn't that neat? Isn't that neat how that works?
It does a good
The,
job
peop
of
the
it.
people who broke the law are trying to use the law against the person who gave us this important information.
I don't understand what the big deal is. It's like, I know I'm not doing anything against the law, like, why do I care?
Wrong, wrong, wrong. Wrong way to see it. That isn't the point. It isn't the point. Not at all. It's about we've been talking for 4 weeks now about why our constitutional system is set up the way it's set up. And that's why this whole issue of not having warrantless searches goes all the way back to the founding of this country, goes all the way back to 1776. That was a big issue, right? So that's bedrock important, right? That's like, it doesn't get any more important than that. I mean, I guess the only thing that could be more important to say would be that the government can't just kill you. That's about, I can't get any more basic than that. The government can't kill you, and the government also can't come and seize, okay, maybe we'll do it in this order. Here's the most important. The government can't kill you without reason. The government can't take away your property without reason, and the government can't search your property without reason. I think, you guys, are you with me on that list? Is that about as basic as it gets? Right, so it's just such a fundamental bedrock principle. You can't let the government start encroaching on these rights, because they will never stop, ever, right? Every government, right? Don't misunderstand me when I'm mad at Obama. Every government under every president tries to encroach on our rights. It's the whole idea. Remember, we talked about breaking away from England. We didn't want a monarchy, and so in this country, what constitutional scholars talk about is it's the fear of the imperial presidency, right? Whoever is running the executive branch, that branch in particular is voracious in its appetite for power, and it's always trying to take away, get rid of the checks and balances, and take powers that belong to the legislative branch or the judiciary branch and pull it into the executive branch. That's why we do it, because it messes up the system. So even I know you're not selling crack cocaine, Ms. Tucker, but the point is, the oversight of these issues about search warrants and that sort of thing, that belongs to the judiciary. That's their bailiwick. That's their responsibility. And when the government and when the executive branch takes control of decisions about searches and seizures, it's throwing our constitutional balance out of whack. Right? The founding fathers put that responsibility with the judiciary for a reason, so that the president couldn't act like a king. Right? Good. So that NSA spying scandal is really one to watch. All right, let's get back to our forums. So we have a traditional public forum. Let's use as an example, let's say, well, let's say Courthouse Square. Like if you went down to the county courthouse and there's a square in front of the courthouse, let's say Courthouse Square. That's a very traditional. Just Ms. Tucker, just to follow on that, there's a very famous privacy scholar named Daniel Solon, and he wrote up this very long law journal article called "Nothing to Hide," right? I have nothing to hide, or something like that, or the problem that I have nothing to hide, and it was sort of an answer to your question all about. Mine was based on separation of powers argument and our constitutional system. His was more about the invasion of the right to privacy. And that's what he did. So courthouse squares are an example. And so what we're going to say as a legal matter, a legal way of expressing it, instead of just saying because it's custom and tradition, we can say that only normal TPM rules apply. Like the only constraints on your First Amendment freedom of speech in a traditional public forum, like a courthouse square, is just ordinary TPM rules. What are ordinary TPM rules? What are TPM rules? Manner. Time, place, and manner rules. Time, place, and manner restraints. And we think of the paradigmatic example would be the noise ordinance. So, High Point, the city, has a noise ordinance that says you can't have noise above this decibel level after 10 p.m. or I think it's between 10 p.m. and 6 a.m. And that's just a rule of general applicability that applies to everybody, and it's content neutral, right? And it's content neutral. And so at Courthouse Square, for example, could you have your No Bombs on Syria rally at 3 a.m. in the morning? No, because the noise ordinance would be in effect, and you couldn't be out there with a megaphone and that sort of thing doing it. Could you also, if you're doing your No Bombs on Syria protest in front of Courthouse Square, could you block people trying to enter and exit the courthouse? No. Could you block the sidewalk? No. Could you spill out into the street and let your protest be out in the street? Well, not unless you want to get hit by a car, right? No, of course you couldn't. You couldn't interfere with traffic. How about this? How about if you didn't want to do it, on Courthouse Square, you wanted to do it on the street in front, or we wanted to do it out here on Montlieu Drive. Can we just go out there and do it? What do we have to do? We have to get a permit because again, a regular type of TPM rule would be a parade permit rule. We would have to go to the town and ask if we could do it. So just regular TPM rules. Otherwise, you have very robust protection. Next lowest level would be, I'm trying to think of an example. Is there a place, like at UNC, there's a place on campus called the Pit, and it's like right in front of the student center. And it's a place where like students will do things like set up tables and have like help feed, the hungry in Africa, and have information, or help fight breast cancer and things like that. Is there a place on campus where y'all do that?
And then in front of Slane Cast.
So is it inside or outside?
But
Where is it?
It's all organized.
There's 2 tables in the UC and there's 1 table in front of the CAF and it's like.
Okay, so let's say we're going to use, when you say CAF, do you mean cafe? Oh, the cafeteria? Okay, so let's say cafeteria lobby, or in front of the cafeteria. Now, that isn't a traditional public forum because it didn't even exist more than, 4 years ago, right? It hasn't been around. But the school has said this place, and the school has said this place, you can do this. And so it's a designated public forum. The school, because remember, this is a private school. This isn't government-owned public property. But the school has designated it a public forum, has said this is going to be a public forum. But notice, a lot of room here, a lot more room here, which means what? Designated.
There's more room for the government to be able to put their own limits on it.
And since we're here, we're using it as an example, High Point University, which is a government. Let's just say there's more room for regulation. There's more room for rules. And so we know it's going to go above and beyond regular TPM rules. So we're going to say, in front of CAF, let's say, obviously the normal TPM plus special rules apply. Now, if you want to use it for one of the philanthropy tables, what do you have to do? Can you just go over there and use it? You have to sign up, right? And you have to say what day, what time. And so the school, even if this was at UNC, they're not infringing on your First Amendment rights because it's a designated public forum and they get to set the rules. They get to make the rules. So TPM, regular old TPM plus special rules. Not violating your First Amendment rights. So keep going, try to extrapolate out, use your imagination. What do you think gets the least amount of First Amendment protection?
On an airplane.
What's that?
On an airplane.
No, an airplane isn't a public forum.
So it's not.
Who owns an airplane?
Okay,
Yeah, private property. You don't have any First Amendment rights on an airplane.
Wouldn't like something like what happened with Occupy Wall Street, like some of it was private property, some of it was public property. Some people were arrested, some people weren't,
Where was it on private property?
or wasn't it like the sidewalks or the street, like that they were.
That's public property. Like in Chapel Hill, they did it in front of in Courthouse Square, right? And they picked it for a reason. You see, there's a legal reason why Occupy took place where it did. There's a reason why the Occupy protests in New York took place where they did. They were in a park. See, so again, an example of how legal rules shape the world around us, whether we realize it's happening or not. But those people were very smart, and they chose that place for a reason, because they knew they got maximum First Amendment protection.
And I know part of the protest though went to like, in front of like the Opera House or something that was near there in New York,
Right.
that movement. And then there was a lot of issues with that because the Opera House was private property, like, I know, like what I'm saying is like.
But it isn't the I know what you're talking about. It's the square in front of Lincoln Center, and that's public property.
Even our media is because they were blocking people. in and
It's
out.
more like that. It's more like they were blocking people and that sort of thing. So they were violating regular old TPM rules because they were disrupting what was happening. But keep going. So if you think, okay, so here are regular TPM rules. Now it gets harder. TPM plus special rules. And so what kind of rules apply here? To give maximum room for regulation.
Like, inside the courthouse or like museum?
Inside the courthouse. It's a great contrast here, right? You could say that outside of Courthouse Square is a traditional public forum, but you could say, why don't we just say as a contrast, let's say the courthouse lobby, right? It's public property because we own it, but it's not there, it's not, just because it's public court, the Supreme Court has said, just because something is public property doesn't mean that everybody can just run wild. So we're going to say it's a limited public forum, and we're going to use as an example courthouse lobby. And that's regular TPM rules, TPM plus strict limits. Strict limits. A limited public forum has strict limits. And those strict limits do not violate your First Amendment rights.
And how does it determine what is limited public forum? Is that just inside any public forum or?
It would be, if there's a question about it, it would be argued in court and the court would decide which one it is. But know this, once something is a designated public forum, here are two important things to remember. Once something is designated as a public forum, it can't be unmade a public forum. So for example, let's say that at the philanthropy tables, let's say a group registered and they had, they're opposed to abortion, and so they had flyers and brochures and signs saying, "Stop abortion now." And the school allowed that to happen at a designated public forum. Then a week later, a group that was pro-choice, we want women's choice, so they applied to do it, and the school said, no, you can't do it. That would be a violation of your First Amendment rights, because why? What is that an example of? What kind of discrimination? Viewpoint discrimination. Once the forum has been designated, the rules must be content neutral, right?
So, out of curiosity then, the designated public forum, for it to violate your First Amendment rights, if I'm understanding correctly, it can only be if the government, designated the public forum, because if it was like High Point University, that's not possible.
Yeah, just keep in mind that with High Point, it wouldn't be the same as if we were at UNC, because that's a government entity. There is a way to sue a private entity for violating your First Amendment rights, but let's not get into that, it's kind of muddy. But let's just keep these local examples, just so we can picture them.
Like I worked at a museum this summer, it was Government Museum of Smithsonian, and so we had the Enola Gay playing, so we were afraid about protesters on like the anniversary, and I guess technically they said we're allowed to give them a warning.
Yep.
So, but like the museum is public property, it's government.
That's right.
So how are we allowed to warn them, and if they don't leave, have them arrested?
You can have them arrested because, again, as the court has said repeatedly, just because something is government property does not mean that everybody can just rampage and do whatever they want. And so the lot or your exhibit space at the Smithsonian is at the most, it's going to be considered a designated public forum.
Okay.
It's definitely not a traditional public forum. At the very most, it's going to be a designated public forum, but I don't even know if it would, a court, I could envision a court even saying it's this. Because, that building, it's not open 24 hours a day, right? Don't you have set limited hours that the public can be in there? Doesn't that sound like there are strict limits?
But during the hours that it's open. Why-
Right, but there's still, it's not, there are more rules, well, I could see a court arguing either one of these, that it's a limited public forum. I think limited, because think about all the rules at the Smithsonian. Like, can you go up and just touch the exhibits? No. Right.
It needs to be-
Do you have to do what the security guards tell you to do? Yes,
Yeah.
of course you do.
it needs
So
to be
there are-
searched before you go in.
Yeah, so there are lots and lots of rules. I would say that there are enough rules in place that it would constitute strict limits. And, I mean, as far as protesters coming in, if they are disruptive and stuff, you can kick them out, right? Or you can call the cops and have them arrested, right? And then they may say, you're violating our First Amendment rights, and then that's what the case would be about.
Okay.
And this would be, let's say it was the protesters, y'all called the cops, got them arrested, the protesters then sued the Smithsonian for violating their First Amendment rights, the case goes to court, this would be part of what the court would have to do. It's called forum analysis.
Okay.
They would have to, and so if you read the court opinion, there'd be a section in it called forum analysis. And they would figure out what type of forum the Smithsonian is.
Okay.
Right. I mean, the way we're doing it in class is the way lawyers and judges debate it.
Okay, so for the designated public forum, if High Point wasn't the example, or because High Point is the example, High Point could potentially say, yes, you can do something anti-abortion, and then no, you can't do something pro-abortion, because it's at High Point.
All right, yeah, let's do it. Let's change our example here, okay, just so that it doesn't cause confusion. Let's pretend we're at UNC Chapel Hill, so that it'll just be straight up. The place where you do that, like the philanthropy tables and stuff, is called the Pit. The Pit at UNC, okay, so now we have very clear and definite government involvement here, okay, so it's a government entity. So yes, they can have rules about, you can only, like at the Pit at Chapel Hill, you can only do your displays between, I think it's 10 and 4 or something like that, and you have to sign up in advance and that sort of thing. And Ms. Tucker, no, they can't allow an anti-abortion demonstration, but then not, they have to allow both. Right.
Can they not allow those?
Yes, that's a very good point. But they can't say abortion. Why can't they specify abortion? It becomes viewpoint discrimination because you're singling out one specific topic. How could they do it then? How could they write the rule? If they don't want big disputes over abortion, how could they write the rule? I guess, how could they do that? I just don't think they could.
Could say things that are too politically charged. I couldn't cite something.
Yeah, but it's still viewpoint discrimination because you're singling out a certain type of speech, right? You're singling out political speech, and where do you know how much?
It's the highest.
It's the highest, most protected speech there is. How could we write the rule if we were UNC? We wanted to avoid having these types of disputes. I mean, because they already designated it a public forum, and they can't take that back. From a First Amendment perspective, I don't think they can, do you? Can you think of any way to write that rule to try to keep people from talking about abortion? Or keep people from arguing over religion? I think once a forum, always a forum, and they're not going to be able to do that. Okay, so is this clear? Private property, not a public forum. It's just not a public forum. Okay, so there's a forum. Yeah.
So, what's another example of a limited public forum other than the courthouse and a museum?
The courthouse lobby, how about, a classroom at UNC. UNC is public property. It's owned by the citizens of North Carolina. But if I'm teaching there and I'm in my class teaching, that classroom has very, very strict rules about who can use it and when. Right. In fact, the classrooms often are even locked when they're not being used for classes, right? So a classroom at UNC. So you see the difference, Ms. Tucker, with Pitt, which UNC, they specifically designated it. The school literally, on paper, designated that as a public forum. But a classroom at UNC would remain a limited public forum. You would have to abide by the rules. Now, let me do it the other way around. So our last stair step, and you're not going to be happy about this, by type of speaker, so this is the floor protection. And again, this is an example of what many First Amendment scholars are irritated with the Supreme Court for creating these different levels, and they would like everybody to enjoy strong First Amendment protection. Who do you think, all right, let's start here. Who do you think doesn't get any First Amendment protection at all? None. Who doesn't deserve any First Amendment protection at all? Okay, prisoners.
I know, like high school students, like you basically sign away your rights, like you really have no protection against what you say in high school.
So you would put prisoners here, you would put high school students. High school students are like prisoners.
No, I'm not saying they deserve that, I'm just saying that is.
But you're saying that they are similarly situated. Prisoners and high school students are similarly situated. Okay? Anybody else? What else? Who else do you think doesn't get any First Amendment protection? Anybody?
Like aliens. That sounds weird. Like people who haven't.
Someone who's not a citizen of
Yeah,
the United
yeah.
States wouldn't be protected by the First Amendment?
Yeah, but they're in our country. Like they just haven't.
Illegal
Only
Yeah, but
illegal?
No, like they're not. Like they haven't received their.
They haven't become citizens.
Yeah.
Okay, so we got prisoners, high school students, and people who aren't citizens of the United States. Here, no First Amendment rights.
I think that prisoners and then non-citizens, but then not high schoolers. I think
So
that
you think high schoolers
would
could
be like the last one.
Oh, yeah, maybe they would be down here.
Yeah,
Okay. So we're gonna
or
put,
anyone under the age of 18.
and you're exactly right, it's because they're minors. High school students here,
But if you're emancipated,
what's that?
if you're emancipated.
If you're a minor, you're still gonna be, well, how many emancipated minors are
I don't really know, but.
Okay. All right, maybe they would be treated a little bit different. Okay, but so y'all's instinct to treat high school students and prison inmates the same is right, but you're wrong that they go here. They go here. And as far as the immigrants or non-citizens, if it's an adult, they go there. You don't have to be a citizen of the United States to be protected by our constitutional law. That's an important point to remember. Is that, because your instinct says, if somebody's not a citizen, why would they have the same rights? But in our tradition, even if you're a non-citizen, if you are physically here, you are protected, just like everybody else. Now, yes?
What about if, I think it's kind of weird because we're not protected if we go, are we still protected by American rights if we go to some other
Nope.
country?
Nope.
So, but are we the only country that does that?
I don't.
So like whoever comes
That's
here.
a good
is protected
question
by-
about, are we the only ones to do that? And I will have to find that out, but I don't, but I think the answer is no. Because I think that, for example, if you were in Great Britain, you would be protected, if you were a tourist in Great Britain, you would be protected under their law, just like
Like
anybody
if
else.
you're in England and you have to go to the hospital, they pay for it, like the same way.
Okay, so
Like as an American, if you go in England under their universal health care, I wouldn't have to pay.
so
At least in
at
England,
least
I
in
don't know about
England,
this.
and let's say England and Australia, we know that you're gonna be treated, because they have similar systems to ours, you're gonna be treated under whatever their legal system is how you're gonna be treated. I mean, I don't think that would work the same in China, so, right. But so adults, but notice this very important difference. Another way of saying that is, in the legal terminology, we would say a private person. A private person is somebody who doesn't work for government. A private person. So I would be up here. I get the most. But what does this tell you? If I told you that this is an important distinction, then what does that tell you?
Well, it depends, like you could say they get more rights because they get more cover-ups, this and that, but at the same time, they're also limited to what they say.
Okay, but yeah, because we're only interested in the First Amendment part of it. So if I tell you that that's an important distinction, what can you reason out of that?
That if you're a government employee, you have to be more careful about what you say, like if you were working at a school with kids, you probably wouldn't be able to get away with some.
And therefore, a government employee
Gets less level.
gets less. A lot less, actually. There's a whole area of law that deals with the protection or lack of protection that government employees get. A lot of disputes. What's some examples of how people who work for the government, of how their speech is limited?
Some public schools don't do it like because it says,
Public schools were so picky.
because it says some, it was like a controversy because it has some, religious.
Well, you don't have to say it. if you don't want to.
That's the
Yeah.
point, is you don't, as a student, you don't have to say it. They can't force you to say it. They'd be violating your constitutional rights if they forced you to say it. And so what has happened is that because of the Barnett case of 1942, that's been true since then. But in some states, the state legislatures, because you're right, there have been cases over the phrase "under God." In fact, there's a case pending right now. I can't remember what state I saw that come out of recently. But the point is, since 1942, the schools can't. Who said the Pledge of Allegiance when they were in school? Yeah, and we did too when we were kids. But you don't have to. You can just not say it, right? And that's because of the Barnett case of 1942. And so in recent years, some states have passed laws mandating that the schools must do it in class. North Carolina did this past year as well. I think about 16 states did this. But they have, with the proviso that the student doesn't have to say it, right? Why does that violate your First Amendment rights if the school made you say the Pledge of Allegiance?
Because it would violate your right to freedom of religion.
You can argue that, and that's what some people are arguing in court when they argue over that phrase, "under God."
Freedom of speech also gives you the freedom to not speak.
Exactly. Because it's compelled speech. The government can't make you say something. And that specific one is called compelled affirmation of belief. The government can't make you say something even if you don't believe it. Right? And it's not even just the religious aspect of it. The First Amendment is very allergic to the idea of oath, of people having to take some oath. Right? Like the government can't make you take a loyalty oath. So government employee speech is restricted in a lot of other ways. Think beyond the school context to other types of government employees.
Oh, it's like a government employee is not in their position, do they have the same rights as an adult?
Now, that is a very interesting question, and that was argued before the court in a case called the Sabalas case only 4 or 5 years ago. Now, our understanding of it used to be a government employee, when on the job, doing his job, performing his or her duties, is here.
Right.
But if the government employee is at home doing something else, they're here.
Okay. Like could just say a teacher like go to a pro-choice rally,
Right.
Be fine. Or
Right, and so we used to, because that doesn't have anything to do with her job,
yeah.
right? And so we used to have that understanding that once the government employee is not at work, that they have more speech rights, but the Supreme Court severely limited that idea in the Sabalas decision. And it was really controversial because, it was about like punishing employees for things that they said away from work. And so now the distinction that the court focuses on is not where the employee is, but if the speech is directly related to their job, they're here. And if the speech is completely separate from what their job and what they do, it's here, right? So they switch from thinking of it one way with a more generous distinction to making your government employee speech rights are robust only in the very narrow context. It can have absolutely nothing to do with their job or their work. That's a good question. And who else?
So I was just gonna say, like, when I started the Smithsonian, I had to sign like an online speech thing, so like what I could say on social media and like what I could mention in a blog and stuff like that.
So government, it's okay then for the government to make you sign a contract that has rules that affect your speech. And because of this room to regulate, the Smithsonian could make your friend here give up some of her speech rights. Let's see, who else goes here? Who else goes here? Oh, well, no, let's keep going for a minute with government employees. What about Edward Snowden? Who worked for, did he work for the State Department? Are you online?
Yeah.
Google Snowden and remind me which department he worked with. He worked in the intelligence community. So this is like, the people who do all the spying and national security and all of that, are they government employees? Yes, they're government employees. Where do they go on the chart? Could be the middle, like if you were working at the Smithsonian, I would say here.
So he was a system administrator
In what department does it say?
in, department as in,
Like, was it the State Department or the
Oh.
CIA or
I keep looking.
something like that? So there are gonna be government employees who don't even get this much because they're dealing with sensitive information and that sort of thing. Let's call them.
Yeah, this is CIA and NSA.
Okay, CIA and NSA, sensitive government job employees like CIA, FBI, the National Security Agency, all of those, these sensitive government jobs, they're gonna get a lot less.
So is there anyone who's not protected?
Those are the only people. If you're breathing, you're protected by the First Amendment. Sensitive government jobs. What other jobs are really sensitive in the government, do you think? CIA, National Security Agency.
Public health.
Hmm?
Public health.
Nah, that'd be more. Like sensitive information that might endanger the nation. Yeah, FBI, CIA.
Executive branch, like the people who work under the president.
If it's in a sensitive area, like foreign affairs or something. Soldiers. If you're in the military, your rights are severely, severely limited. Part of it by the military code of conduct, part of it because you have to sign literally what amount to contracts and agree not to talk about things and that sort of thing. They have to agree not to do certain things on social media and that kind of thing. High school students, prisoners, sensitive. All right, what about y'all? What about college students? Where do y'all go? Okay, public and private then. All right, let's deal with UNC Chapel Hill students, public university students. Probably middle. They're not going to be treated like adults, not because they're not adults, they're over 18. Yeah, and because through court cases, the courts have ruled that the schools can limit.
So, does that only apply if you're on the campus? Or?
No,
So the fact that you're a student, just in general?
it depends because if you're a UNC Chapel Hill student, you get this level of protection, and then if you're at home, you get the high level of protection unless it involves school.
Yeah.
If it involves school in some way, the courts, I'm not saying I want it this way, I'm just telling you how
Yeah.
courts have ruled on this stuff. They've allowed school, this has gotten worse and worse over the year, but they allow the school, if it's related to school, to reach you, like punish you, that kind of thing.
So, for example, what's an example?
An example would be if you're a student at UNC Chapel Hill and on your Facebook page, you wrote all kinds of defamatory stuff about the school and school administrators and that sort of thing. And then if the school disciplined you in some way, and they demanded that you take it down and they did this, and you said, no, you're violating my First Amendment rights, it would be a real crapshoot as far as that case, because the courts are becoming more permissive. Because you would think, wait, this is off-campus speech, this is in the privacy of your own home. But through a series of court cases, the courts are becoming much more permissive in terms of letting the schools punish you for speech that didn't even happen at school. right? It's a great example of how the internet has complicated things. Because when you say something on the internet, where are you? Are you at school? Are you at home? Are you lost in space? Are you in the cloud? I mean, where are you, right? It's the whole area of law called jurisdiction, figuring out jurisdiction, has been really complicated because of the internet. So ever since, and the courts are funny, they'll start doing things like infringing the rights of high school students, and then in recent years, some of those types of court decisions about high school students have been drifting up and affecting college students too, right? The Bong Hits for Jesus case is all about the Bong Hits for Jesus case. The Bong Hits for Jesus case.
Olympic run or something like that.
What's it involved?
What is that?
It was a high school case that involved high school students, and it was the Olympic torch was running through town. And so the school had taken a field trip. They all went from school on a bus, and then they were downtown. I think they were in Seattle, and they were on the sidewalk. So now what do you think? If they're on the sidewalk, how much First Amendment protection do they get?
A lot.
A lot.
Yeah, but they're high schoolers.
And when the torch went by, a few of the students, they unfurled this humongous banner. It was like I don't know, 20 feet long, and it said "Bong Hits for Jesus." And so the school punished them, and then they sued. And it was a real surprise decision because everybody thought, just using regular old forum analysis and the fact that it was off-campus speech, it was off-campus and it was in a highly protected speech zone, which is a public forum. But what did the court decide?
Well, I was going to ask if they ruled, I'm assuming they ruled against them. And I was going to say, did they do that because it was on a school-related trip?
That was the rationale. Because even though it was off campus, it was still a school function, and the school was still responsible, in loco parentis, it was still responsible for the students.
Wouldn't it have been, well, actually, never mind.
What?
Well, I was gonna say they're high school students anyways, so they had low.
Right, so we're already saying, so the court then couples these two ideas. They already get lower First Amendment protection anyway because of the Tinker standard, and because even though they were off campus, they were still under the authority of the school people.
So is there like a type that has more precedent than the other? So like high school, because they were high school students, that took precedent over that they were in a public forum?
Yeah, that's what ended up happening. They trumped the idea that they were in a public forum by saying it's because the Tinker standard, all of these student speech cases flow from the Tinker case, and so we can say the Tinker standard is what places them at a disadvantage. The case is Tinker v. Des Moines School District from 1969. And the case was about students who were protesting the Vietnam War by coming. It was a silent protest. They weren't even speaking. They wore black armbands, and the school sent them home and told them to take the armbands off. And they sued, and they won. So that was the First Amendment victory for high school students. But in the case, the court says that the students have First Amendment rights. This is where that famous phrase that the students don't give up their rights at the schoolhouse gate.
Oh, well, you can keep this is for after.
Okay. But speech that is disruptive or speech that disrupts the educational environment can be regulated by the school. And so the courts have taken that idea and have in recent years, instead of siding with the students, they've been siding with the schools and saying everything's disruptive. So the Bong Hits for Jesus, disruptive of the educational environment. So the Tinker standard, it's funny because the Tinker standard started out being very protective of student speech, and now it has been turned upside down, and it's being used to protect the school's ability to punish students. And as I said, then the worrying trend in the last few years is to see some of these high school cases used as precedent to curb college students too. How about y'all? So this is public university students like UNC, and how about y'all? Well, actually, I'll just put it here. Y'all are down here with the prisoners. Right? You're learning in an inspiring environment that's like a prison.
It's a very expensive prison.
That's very expensive. It's the nicest prison I've ever seen. Yeah, unfortunately, the school can restrict your speech and press rights a lot. But they don't much, do they?
Is that because of like stuff we signed when we accepted like our?
It's because this is a private
Yeah.
school. And so if you tried to sue the school, like when the school shut down the separate student newspaper and really downsized the student newspaper, you know, at UNC, that would have been an instant lawsuit, and the students would have won. But here, I don't know.
So what would be an example of a case that a student here would win? Like something that HBU couldn't do?
Well, I think, I don't want to get into this area of law, but I will just tell you this, because I don't want to muddy the waters. You remember how we said because of state action doctrine, that means without government involvement, no constitutional claim can be made. Here at HPU, there isn't any government involvement because it's a private school, but there actually is a way to sue a private entity for violating your First Amendment rights. It's Section 1983 constitutional claim. And so there would be a possibility, but it would have to be serious. Like, for example, well, let's be creative here. I mean, let's just kind of think through this. What if you had a website, and your website, like your student group had a website, and it was Students Against War on Syria. And so the website was just full of, you know, very highly charged political speech and editorials and all of, and like that. And the school came to you and said, well, we're in favor of war in Syria. We want to drop bombs on Syria. And you think I'm kidding, but apparently a bunch of people do, right? I think they're insane, but anyway. And if the school, because it's on like the school server or something, they would use it as an excuse or something, and they shut down your website somehow. I don't know how technically they could do that, but let's just pretend like they could. I don't know how that works. But let's say they shut it down. Well, that's a very serious kind of abridgment of your speech because it's a prior restraint. That's what we'll talk about next week. A prior restraint is the most serious thing that the government could do to violate your speech rights. And so I would think it would be the most, the worst thing that this university could do if it literally stops you from speaking. That's a prior restraint. They're restraining you in advance, keeping you from speaking. So I think I have to think about this and maybe even research it a little bit. So I think that you could try to make a Section 1983 constitutional claim against a non-governmental actor in that case. But I'll ask some colleagues who may know better than I do as far as how you would litigate that. How would you make the argument? Right. So it's possible. Maybe part of it would be, maybe you would argue that does this university get any money, even $1, from any kind of government agency?
They used to have the North Carolina grant, but they got rid of that last year.
I doubt it.
So it was some sort of grant from the state of North Carolina, because if they were getting
If
any,
you
Yeah, but
went
they
to
cut
a
it.
private college and you were a resident of North Carolina, then you got like, yeah, it was like 2,000, and then they like cut it back, and then they completely.
that was the whole-
so that was the state legislature cut that money. Okay, let's say that if it was still like that, and you guys were getting $2,000, now you could say, there is government involvement. There is state action. The state of North Carolina is giving some money to High Point. That's how you would get around the state action doctrine problem.
What if a government employee is a parent and was donating?
To the school?
Yeah.
No, because they're not an agent. I mean, they're not part of the government. Oh, okay, wait, are we done? Are you sure?
Yeah.
Yeah, like, I just want to make sure we got everything up here. All right, we're all up here. Thank you. That's it for today, Daniel. End of week 4.